A former Marine is suing the federal government for $1 million. Fitzgerald Scott was arrested in the U.S. Supreme Court building, for refusing to take off a jacket that had the words "Occupy Everything" on it. He was charged with unlawful entry. Scott says his First Amendment rights are being violated here. The Obama administration disagrees, saying Scott could have actually been charged with violating the display clause, making it illegal to draw attention to a cause inside the Supreme Court or on its grounds. Joining us now, David Schwartz, defense attorney, former prosecutor. Lise Wheel, Fox News legal analyst, former federal prosecutor. So, Lise, should this former Marine prevail?
I think he probably will. I'm not sure he's going to get the $1 million that he's asking for in damage. He's got to prove damages. But what the administration is saying, well, he could have been arrested and charged under the display clause, and I've got the display clause right in front of me.
Let's put it up on the screen and read it, because this is the important part about it. It's unlawful to parade, stand, or move in processions or assemblages in the Supreme Court building or grounds, or to display in the building and grounds a flag, banner, or device designed to or adapted, I got to put on my glasses, to bring into public notice a party, organization, or a movement. Now, I studied that. I can't figure out how Occupy Everything qualifies.
Well, what the administration would have to argue, and David, chime in on this, is that Occupy Everything is a flag or banner or device wearing something. I'm not saying I believe in this argument. This is what they'd have to say, and that brings attention to the Occupy Wall Street, Occupy Everything movement.
You buy that?
This is a disgrace, Greg. This is an absolute disgrace. This is an absolute false arrest case, and you know, it is a violation. How could you say that something on a jacket or a shirt is somehow a flag or a banner of some sort? That would be like if you're wearing the American flag or you're walking with a polo shirt. They can arrest you also. This is a disgrace. This is the very building where we got all these civil rights in the first place. And now this,
well, you could probably be busted
arrested
for wearing Ralph Lauren. But, but I have a little button that says "I love America." Now, I'm willing to bet I would not be busted.
I don't think so. And then you have officers making that decision of, you know, I like this one, I don't like that one. And also, Greg, there's a Supreme Court decision that Dave and I were just talking about, a 1971 Supreme Court decision, Cullen versus California, where a guy walked into a Los Angeles, California court, and he was wearing an expletive F the draft, And the Supreme Court said, the same body that we're talking about now said, that's the First Amendment. It's covered by the First Amendment.
And this is just Occupy Everything. That doesn't even compare.
Here's the other thing. The Supreme Court has repeatedly said that free speech is not entirely free. Time, place, and manner restrictions are permissible as long as it serves a government interest. Now, what is the government interest inside that Supreme Court building? He's not yelling, screaming, disrupting order.
He was looking at a slavery exhibit. I mean, he wasn't doing, if he was there wearing this or with a group of people who were wearing this, and that was getting, motivating others to violent acts, something like that's completely different.
It was an empty building. I just watched the video.
It's empty.
It's an empty, there's a few people around. The other protesters are outside the building, so he had no chance of riling up the crowd. He was asking questions.
Here's my question. Why is the Supreme Court so important or more important than any other location where free speech is permitted?
Well, the display clause only applies to the Supreme Court. And, you know, it's what the Supreme Court is saying, what the administration is saying, it's a First Amendment free zone at the Supreme Court. Really?
Right. And I'm not sure the display clause has ever been constitutionally challenged.
Yeah, and this is a hypothetical situation. This is a hypothetical parade or riling up the troops or whatever you want to call it. It never happens. It's ridiculous, and he will prevail.
But you know, the other thing that the Supreme Court has said, it has to be, your restriction has to be content neutral. Well, I think there could be a violation of that.
Meaning, exactly. Meaning, whatever is on your shirt, it's not upsetting to one person. It's not about what it says. But to your point, David, there were people that were arrested saying the same thing outside of the courthouse.
And they made sure they did the unlawful entry and not the First Amendment. They were very careful about the arrest.
All right. Lise Wheel, David Schwartz. Good to see you, though.
Thank you, Craig.
And we'll be right back. Don't go away.